Hi everyone, I'm Belinda Winter, a partner at Cooper Grace Ward in the Workplace Relations and Safety team. Today I want to talk to you about how you affect employee redundancies. This can be a very stressful time for employers and for employees, and it's really important that you deal with that sensitively. But leaving that aside, I want to talk to you about the strict legal issues that are involved in this. The first thing is, a position is made redundant, a person is not made redundant. So if you're wanting to move an employee on from the organisation, you don't do that by affecting a redundancy that is not genuine, because you will be called to task on that. What you need to do is to decide whether the business needs that position to be performed by anyone within the business. If the answer to that is no, then you probably have a redundancy on your hands. What do you need to do then? Well, once you've made a decision that an employee's employment needs to come to an end due to redundancy, before you make that final decision, you have to consult with the employee. This is particularly important where you might have a whole group of employees who may be made redundant over other employees who are performing same or similar roles who are going to remain with the business. They're of course going to ask, why me? And you need to be prepared with an answer for that. And I suggest the way that you do that is to consider the employee's skills and capabilities, record those and assess them objectively with other employees. That way you can be confident that you're not making an unlawful decision, and if challenged, you can go to the Commission and produce that evidence. Once you're satisfied that you've selected the correct employees, you then should consult with them in a one-on-one meeting. This gives them the opportunity to perhaps suggest some alternatives to terminating their employment, for example, special project work or perhaps redeployment. And it's important that you give that consideration. The other important thing that employers need to understand is if there is another position available in the business that the employee does have the skills or capabilities to perform, even with some additional training, it is the obligation of the employer to automatically redeploy that employee into that position. If the employer doesn't do that, it cannot rely on the genuine redundancy exemption in the unfair dismissal laws. Now, if you're not concerned about that, because perhaps your employee isn't able to make an unfair dismissal claim, then that's fine. But if your employee does have access to unfair dismissal, you will be questioned about the genuineness of the redundancy and the availability for redeployment. We find some of our clients ask employees to participate in an open application process, and it's not meant to work that way. It's fine if you take expressions of interest from multiple people within the organisation for one job, but you can't ask them to compete with people from outside the business. That is not automatic redeployment. So once you've consulted, once you have decided that redeployment is not an option, it's time now to give the employee notice of termination, notice of their redundancy pay and any other entitlements, and then decide whether you're going to ask them to work out their notice period or give them pay in lieu of notice. If you have EAP, it's a good idea to offer this to the employees, not only for the ones departing, but for the ones that are left behind. Thanks for listening everyone today. The next topic is going to be how to pay people under awards and how we do that by paying them a salary.